Good morning. I trust you're all well and that you can hear me clearly. We had some issues with the previous video. I hope this one works out very well. We have some guests on Zoom. Let me just put them in, allow them in. Okay, wonderful. Yes, our Zoom people are in as well. And hopefully we'll be able to do a good webinar. We had quite a few questions being posed to us previously. And I think there were quite a lot. And I've placed them on our system, and I've only chosen 6 of them, and for the rest of the week I shall deal with the rest of them, so that's fine. If you have posed a question, you are welcome to interact with me via Zoom. There is somebody in Zoom, but that person is not planning on partaking via video. The person would like to hear via Zoom what my response to the specific question is, and I'll be happy to do so. That's not a problem. And if you look at the screen, you'll have a full view of the question that is being posed, and I shall deal with that accordingly. Nonetheless, you are welcome to join the Zoom link via visiting www.ourlawyer.co.za. And at the same time, you are welcome to ask questions via the Advocate Muhammad Abduroaf Facebook page. So I hope we'll sort that out shortly. There's some technical issue to sort out. If you cannot hear me or there's any technical issues that side, please keep me posted and let me know. Nonetheless, let us start with the first question. Okay, the first question is quite long, and obviously I will not read the entire question out for you. It's quite extensive, and the specific questioner will obviously know what the question is. But having gone through the entire question, I basically come to a point whereby I can determine what the question is, and that is, how do I get him to pay the increase for the last 2 years and also to assist me with tertiary education. Okay, so how do I deal with that specific scenario? The specific questioner says basically 2 years ago she approached a maintenance court for some type of arrear maintenance, and now she's struggling financially to maintain the minor child, and she's now at the wit's end, and she now wants to know how does she go about in claiming arrear maintenance or maintenance for the last 2 years going forward. The long and the short of the matter is, if the maintenance order does not provide for certain items of maintenance to be paid, it could be clothing, school fees, whatever it is, then should you wish to enforce something other than what's in the maintenance order, unfortunately you would have to approach the maintenance court again for that. That is just unfortunate and something which you have to do. I cannot advise you anyway further where that is concerned. Furthermore, if the maintenance order stipulates that he should only pay for X, Y, and Z, but at the same time there is an inflation clause in that specific order stipulating that at the anniversary of this order, the other party should pay an increase of 10%, or based upon the Consumer Price Index, CPI, then that would obviously be of assistance to you, because basically it means that at present the order is, for example, 1,000 rand per month, which the other party must pay, but at the same time, should the anniversary of this maintenance order come about, the maintenance would by default increase to an amount of 1,400 rand, depending upon the CPI amount. Now, going forward, let us go going forward over here. Giving advice to the specific questioner, you now want to know whether or not you can claim maintenance for the last 2 years, because now you've incurred a lot of expenditure for the minor child for the last 2 years and the father did not pay it. The maintenance court can assist you. Remember, maintenance is not based upon the amount of money the court makes an order on. For example, if the court makes an order that the father should pay 1,000 rand maintenance per month, but last month the child actually cost 3,000 rand per month because the child had to enroll into a school, or the child had certain medical expenditure, or something that's happened where the minor child's expenditure became much more. Because of that, by default, you are allowed to approach a maintenance court and tell the maintenance court, the current order says the father must pay 1,000 per month, but last month I incurred an amount of 3,000 rand for the month, 3,000 rand for the month of May for the minor child, for example. The maintenance court can relook the entire matter and say, you know what, the maintenance order 1,000 rand a month continues, but for last month, sir, you have to pay an additional amount of maybe 2,000 rand per month, or at least half that additional amount of maintenance which the minor child has incurred. So when it comes to child maintenance, the maintenance order is not the start and the end of the responsibility of the other party. The maintenance order can change at any time. One change could be where the other party, the party that has to pay maintenance, his or her income has increased, his or her financial position has bettered, or it has decreased and it has changed and it went worse. And the same way for the primary caregiver, the person who's claiming child maintenance. That specific person can say, you know, I lost my job, I'm earning less money, therefore he or she may approach the maintenance court for an increase in maintenance and so on. So where I'm going to with this is, it does not mean that the maintenance order said X, Y, and Z, and you cannot claim for the last 2 years if you have incurred much more expenditure which the maintenance order has not taken into consideration. So I hope that answers your specific question. You mentioned a lot of information, a lot of details. Obviously it would not make sense for me to deal with every point. I think the bottom line over here is, your question was, how do I get him to pay the increase for the last 2 years and also to assist me with the child's tertiary education? Quick answer would be, approach a maintenance court for an order that he should have contributed more for the last 2 years, and obviously you have to justify your case and you have to be successful in your case. And at the same time, if you would like him to pay for your tertiary education, and that is not stipulated in the maintenance order, of course the maintenance court can make an order that he pays the tertiary education as well. So that's where we go where that is concerned. Okay, question 2. Let me change the view. Okay, question 2. It is a family law, but something which we do not usually deal with in our platform. We usually deal with child custody, child maintenance, relocation, guardianship issues, consent issues, and so on. But because the person posed a question, I would obviously deal with it, and I do not mind dealing with it. Basically, this person was a second wife. The husband passed away, and obviously both wives succeeded him. A lot of things happened since the death. There was things that had to be paid. The people went to the High Court and so on. But the only question I could actually see from the entire request or registration of this question was, can I send an email to the judge advising of my challenges and report the advocate work ethic? Okay, so that's basically all that I can pick up. It's a lot of jumbling of data and information. And it mentioned I went to court and this is what happened and these are the problems that happened afterwards. So obviously it makes it a bit more difficult for me because there's no specific question that I have to deal with. But I'll be able to deal with a specific question. You cannot email a judge. It doesn't make logical sense. You can email a judge certain relevant documentation. That possibly could make sense. Let's say, for example, it's COVID-19, which is and it's lockdown, and you have to send the judge a certain document that you filed previously at the court. Cannot find it, of course, and the court has to deal with the matter. You can maybe email the judge that, or email the judge a draft order, or some relevant document. You can email the judge, but you cannot email the judge data and information. The court process does not work that. The way the law works and the way the court process works is, if you want to submit certain information and documentation to court, you have to do it via a legal process. For argument's sake, if you would like to divorce someone, you have to institute divorce summons against the person, so you have to serve the divorce summons against the other party. But however, you'll first draft the documentation, you'll have it issued, have it served on other party. Internal processes will take place. For example, the other party might want to plead to it, come with a counterclaim, discovery, and so on, etc. will take place, and then ultimately the court will have to make a decision on the case after hearing both sides of the story. That's how a matter is heard in court. Judges aren't sitting there just to receive data and information from people randomly, and based upon that make decisions on matter. That doesn't work that way. You present the information via the rules of the court, the High Court rules or the Magistrates Court rules. You make an application, you serve the application on other party. Ultimately, once that has all been done, then the matter will be before a court, and the court will make a decision after hearing both sides of the story. So I hope that sorts you out where that is concerned. I really feel sorry for the problems that you are going through since the death of your husband. And I thought about it when I read through your questions quite a few times, is that it may be best for you to obtain the services of an attorney to assist you with the specific legal problems that you have. Okay, question number 3 is more of a complaint, I see. It goes as follows. Why are there still so many single moms having to fend for their kids' school and work? Don't understand that we have this alone and that we cannot yell for when our child needs us. Is there any way I and many other mothers moms can be protected without getting battered verbally by our boss or school saying we are incompetent in a nice way? That is obviously a complaint which you have against employers. I do not know if all employers are that acts that specific way. Let's say, for example, the child is ill and the mother, no one is there to care for the minor child, and unfortunately the mother has to go to work. She's a single mom, but the child is very ill. So what happens then? She takes time off work, phones the boss. Boss, sorry, I cannot go to work. My child is very ill. There's no one to look after him or her. I cannot take the minor child to daycare because he's coughing and sneezing and with COVID-19 and all those specific issues. Sorry, I got a comment over here. Okay, that was somebody from the Zoom stipulating that he appreciates the advice and he had the answer. So I think I have answered that specific question early on. So let's end that specific aspect. Sorry about that. I had to deal with that. So moms are find it very hard. I mean, single parents, single dads as well. You know, you work for a boss, and the boss expects you to come to work every day and to be invested in his or her company, and he pays your salary at the end of the month. But now you have family commitments. You know, the child's teacher phones you, the child is struggling in school, you have to take time off work, parent meetings and so on. So we have the challenge whereby the school gives you certain slack or certain problems or certain, lip, if I'm looking at the question, because you're not always available to come to school and, speak to the teachers regarding your child, and the employer on the other hand gives you the same type of slack because you're not focused, you're not committed to the work because you take a lot of time off work for your child. And obviously either way, it's not right, it's not fair. And the law should come to the assistance of parents from all aspects. But at the end of the day is if the school or the employer acts unreasonable, then that is obviously a complaint you can have against that specific school. So there is no specific legal question here. For example, the legal question would be, if I take off work because my child is sick, of course, the labor law says, you can take certain type of emergency leave and so on. But I certainly know that. But I find it very disappointing that the attitudes of schools and of employers, and obviously I'm not generalizing, I do not know which school this person is referring to and which employer this person is referring to, but if this is true, obviously it's something which is concerning and something that must be done about it. Okay, that's question number 3. Let's get to question number 4. My son's father didn't attend our first hearing at the maintenance court on Thursday in Durban, but he says he was granted an audience with a magistrate in Pretoria on Friday. So we're dealing with Durban, we're dealing with Pretoria, okay? Is this normal? No one even looked at my file or let me know any of this. I filed the maintenance. Should I be consulted or informed? Okay, so here we're dealing with a scenario whereby The father told the mother something we do not know if it's true. Maybe this went to the maintenance court in where he resides in Pretoria, I presume so, and had a chat to a magistrate there. But we all know the law. The law says a maintenance court can only a maintenance court only has jurisdiction to hear a maintenance matter or maintenance complaint if if the caregiver, in our example, the mother or the child lives within the court's area of jurisdiction, or the mother works in that court's area of jurisdiction. So if the mother lives in Durban with a minor child, and the father went to Pretoria court, I think he could have had audience with the magistrate, but I doubt